Construction and Planning Agency recently approved the plan to build Makao Chinese Cypress National Park, which had been shelved for years. Now there are debates on whether the indigenous members should also join the decision-making process as stipulated in the Indigenous Peoples Basic Law.
The plan to build the Makao Chinese Cypress National Park has been revived. But what power does Indigenous Peoples Basic Law have over the proposed project? An official from the Interior Ministry said the government would adopt the spirit of Indigenous Peoples Basic Law in the planning process.
The Interior Ministry's Laws and Regulations Department did offer their legal advice. At that time, they provided us written comments saying that there were no conflicts against the laws, so we started planning for the national park. We have adopted the joint management mechanism listed in Article 22 of Indigenous Peoples Basic Law in planning Makao Chinese Cypress National Parks.
The agency says Indigenous Peoples Basic Law has no binding power over Makao Park since it was adopted in 2005, whereas the boundaries of the proposed park were announced to the public in 2002. However, some scholars say announcing the boundaries is only part of the planning process, which should follow the Indigenous Peoples Basic Law.
From a legal point of view, planning includes outlining park boundaries as well as establishing the park. So obviously, details of the proposed park to date, as we are speaking now, have not officially been laid out. They have outlined the boundaries, but have not worked out the complete plan. So of course, they must get prior approval from the indigenous people.
Whether the Makao Park project needs to gain prior approval from the indigenous people under Article 22 of Indigenous Peoples Basic Law is still under debate. With the amendment to the National Park Law pending, the indigenous members are wondering how their rights can be protected in the park project. TITV Weekly.